Hi everyone, it's Grant Abbott speaking, and welcome to this special session on asset protection. Both myself and also Michael Jeffriess from Lightyear Docs, one of my directors, and also from Eventum, Optimum, you're going to hear a lot about. So how you going, Michael?
Thanks, Grant. How are you?
Yeah, good. A couple of things while we're up front is that we have got a couple of important announcements. One is that on November the 18th, we've got a 2-hour session on Estate Planning 101 with myself and also Tony Anaboulos, and we'll have a few other participants as well. For those of you in that succession, asset protection, estate planning space, and we'll be coming out with some pepper stuff a little bit later on. But it's important that you come to that session so that we'll be able to show you how, as an accountant or a financial planner or even a mortgage broker, how effectively you can provide both estate planning advice and also prepare wills, enduring powers of attorney, and also advanced healthcare directives without breaching the Legal Professions Act. So we've virtually nailed it, but we want to show you on that session. So make sure you book that. It's in November the 18th. We'll send some information out a little bit later on. The other one is for those of you on the Gold Coast on the 27th of November, we're poking your head up and we're running a breakfast down on the Gold Coast with details to be announced. But that's a 2-hour session running from 8 till 10. We'll be covering a lot of strategies, a lot of asset protection, and also looking for people to help us along the road in that establishment of the Succession Asset Protection Estate Planning Advisors Association, which is really exciting. Now, it's 11th of November. We've gone past 11 o'clock, so sorry we're not going to have a minute's silence for us. But anyway, let's go down the track on that one. So just turning to the first slide, asset protection is one of the first things that you learn at university, whether you're studying an accountant or financial planner. Lawyer, not so much. I mean, really, I remember when I was doing my Bachelor of Laws at Sydney University, even tax, we had 10 1-hour lectures, and then suddenly we're supposed to be tax experts, which is crazy. But certainly, asset protection is really crucial. For your clients, really, wealth means nothing if it can evaporate at the minute at the whim of a regulator. Look, I just lost, I think, about $1,300, my fault. I had a car over I rented a car over in Adelaide going around about 6 or 7 months ago, going to see mum and dad who were in nursing homes. Dad since passed away, but I got hit up with 2 traffic infringements. And of course, I forgot all about them. They didn't come to me. They went to mum's old place. And as a consequence of that, suddenly I went into my bank account at one stage and found there was $1,300 missing. And that was effectively the garnishee orders and costs were deducted straight away from my bank. So garnishee, you've got to be really careful about that. Is a great way to reduce wealth. With asset protection, if we have a look at a ranking, obviously with asset protection, the worst asset protection is having assets in your own name. The second one, which is traditional and it's certainly very dangerous, is having it in the spouse's name, particularly if there's a separation or divorce. Again, assets, if you have a look at possession, is 9/10 of the law. If it's in the spouse's name, it can effectively get thrown out, closed out, do whatever. So again, it's preferable to have it in some other vehicle. Company's not too bad, but Michael's going to talk about company and insolvencies, etc. They're not that fantastic when it comes around to asset protection. Then, of course, we've got the trust, which is our key go-to, particularly as accountants and planners, our key go-to asset protection mechanism. But that also has its weaknesses as well. And believe it or not, the top of all, who I'm going to prove to you today, I'm going to do a deep dive a little bit later on after Michael does a bit of an intro session into SMSF. So I'm going to show you the law, the regulations, the legislation, and a couple of interesting ones to show that SMSFs, hands down, are the best for asset protection. There are a couple of caveats there, but certainly SMSFs and superannuation are the best. I'm going to also have a look at a case study on that one. So with the COVID bankruptcies and insolvencies, really there hasn't been that much. It's almost like there's a tsunami that has hit Australia, and that's the COVID tsunami. Now the water's really flown in and it's now starting to flow out. So we're going to start to have a look at next year where things are, and Michael's going to have a look at that in a second. Now, asset protection, when you come down to it, you've got to look at is most of us focusing on asset protection as a lifetime issue. Accountants have got to look at this being long-term. I know you deal with clients from an accounting perspective when they're running business, but we need to continue not only beyond that, but also beyond their death, because asset protection, if you've got a family provisions claim, all the wonderful structures and strategies you put in place effectively can get dissipated through a family provisions claim. And it's not just the claim against that, it's also the legal costs. So legal costs can easily be the hugest part of a wealth destruction tool. So we've got to be extremely careful about that. And I know insolvencies and also trustees and bankruptcies, they're of course the first ones to get paid. Isn't that right, Michael?
That's correct. That's
funny about that, isn't it? It's a system set up for them. So that obviously means that there's going to be a lot more litigation, etc. So I'll hand over to Michael, who's going to really talk about the fact that tsunami is now starting to drain out. We've started to see JobKeeper is being reduced down to $150 supplement, but both of those, JobKeeper and that extra supplement for JobSeeker, will run out, and so then effectively the individuals who are not working will be on around about $580 a single. I think it's 500. Oh no, so yeah, around about $580 a single a fortnight. So let's. Do you want to take us through where we're at? And I can see Australia on the cliff face there.
I will do. Thanks, Grant. And feel free, everyone, just to jump in chat and put your thoughts on where we're currently at and where we're sort of headed. I'd be interested to see what everyone else feels out there. I've always been, I guess, the forever optimist, and my wife is the polar opposite of me. Is always a pessimist, but for once in my lifetime, I'm actually starting to feel quite pessimistic about where we're at and potentially where we're headed. But I'd love to see what everyone else is thinking about that. So be it 2021, be it 2022, I believe we're heading for a cliff face. There's been a significant amount of government stimulus for COVID. I believe it was the right policy to put in place, and then it's achieved at the most what it should have. But we're now seeing the runoff or the end of going through to March of JobKeeper, JobSeeker, cash flow bonus has now ended in relation to PAYG withholding. Our Super 10K withdrawals, Grant spoke about it yesterday, but there's a significant amount come out of institutional funds compared to SMSFs. What was that? What was the difference in numbers you mentioned yesterday, Grant?
Yeah, it's quite amazing. It's I think it's up around about $30 to $32 billion, maybe even higher from industry and retail funds. But it's for self-managed. The tax office just come out with their stats and said it's just over 250 million. So over 250 million. So obviously people in SMSFs have probably, they're a different dynamic anyway. So they're pretty well off and well to do. But certainly it's a huge difference. And there'll be a lot more bleeding, I can tell you, between now and 31 December.
Yeah, I agree. So there are other things that are sort of impacting this. Obviously, there's an end of the bank and financier blanket moratorium of repayments and interest, and holding back on that around mortgages, car loans, credit cards. I know we had a client in Eventum Optimum we started talking to pre-COVID, and then as soon as the banks and the financiers announced that they would put on hold his car and mortgage repayments, he no longer, he's put on hold our services. And he said, look, I'm fine now. I don't have to pay anything. I've been able to negotiate with my landlord. And I said, well, that's great for now, but what about in 6 months' time? And we should be putting the steps in place, which we have been working with a number of clients doing that, but it has been an interesting period.
Actually, it's really important, as you're saying that, is people don't understand it's not a forgiveness, it's only a deferral. So you're still going to have to pay that money back. Importantly, though, from a solvency perspective, it's not a bad idea to do restructuring, re-energising, and have a look at that asset protection, because once obviously you do if there's a creditor petition under the trustee and bankruptcy under the Bankruptcy Act, or a credit event, that's when things start to really happen and relation back starts to look in.
Exactly, and then that's why you want to be that's why you want to be reviewing your clients now, your client list, speaking to any of those where you believe there may be distress. Often it's the clients that you may have lost touch with as well, because they sort of, I guess, they bury their head in the sand, and it's often get hard to get in contact with them because they don't want to deal with their problems. But I know you referred a Lightyear user to me recently, Grant, and we were we worked with him in relation to re-engaging his client and through Eventum Optimum, and that client was finding a fair bit of distress, but he was the accountant was actually struggling re-engaging the client because of they buried their head in the sand and didn't want to deal with it.
Yeah, and importantly from that one, that was also a spouse who'd been left in business on the death of obviously their husband, who was the main driver of the business, and obviously just kept the business going. So there was also another issue in there that really, to get involved, is we've got to make sure we have really good succession plans, successor directors and all that. So all of this pepper stuff, succession, asset protection, estate planning, all is this one great big circle that we need to work in. And you can't just sort of sit in one little area and say, okay, I'm going to do tax and compliance and that's it, because that's not what the business about accounting is. Really, from my perspective, is accountant, and also to a lesser extent, the financial planner, trusted advisors, and all of those strategies need to be brought to bear in one way, shape, or form.
That's right. I mean, succession is one of the things that's often never looked at, and until it's too late. So obviously, we've also had the end of the COVID safe harbour measurements. I'll go through in the next slide around safe harbour, but it got introduced in September 2017, effectively into the Corporations Act. But during COVID, they introduced some preliminary measurements around safe harbour on insolvent trading, and so they've now ended. So that's another push of the Australian map off the cliff. There's people are talking up. And there was an article this week around it again about a major housing collapse in Australia. The numbers I saw, which I've quoted there, was that New South Wales and Victoria were down 37%, which was a greater fall than the US housing crash. We're working in a low interest rate environment. People are being able to borrow at low interest rates, whether if interest rates change in the future, there'll be questions around affordability, obviously. I can't see them changing in the medium term.
I can't see it for 10 years at least, I think.
No,
I think this is, look, I don't know, and I don't want to do that because I'm super optimist, but, I can see that there's certainly great issues coming down the track. And particularly, as I said yesterday with Australia, China's decided to make an example out of us. Because we had the temerity to actually say, well, hold on, the COVID started in your neck of the woods. Why can't we have an international investigation in it? So China's decided to attack us rather than, for example, the US at the moment, and we don't know what's going to happen there. But look, a lot of this sort of stuff, we're down on international tourists, we're down on international students. There's going to be a huge reverberation. So it's certainly going to be interesting. And obviously in Australia, I think it's going to be pockets of the property. I'm up here on the Sunshine Coast, which really, to be brutally honest, hasn't moved in, about 10 years. But suddenly it's picking up because we're getting people from New South Wales and Victoria are relocating up here to the Sunshine Coast where it's cheaper. They can work remotely and still effectively do their job. Hasn't ticked up a huge amount, but certainly rather than having a for sale sign there for 6 or 7 months, they're virtually going sight unseen. I mean, what's it like down the Goldie?
Oh, the Gold Coast is extremely hot at the moment. Almost hot enough to have concern. I spoke to a client only yesterday, and he said he went to an auctioneer for the public trustee on the coast and for a resi property, where you'd normally get maybe 5 or 10 people turn up, and there were 54 registered bidders, and it went $50,000 over reserve. And from what I'm seeing in the unit market, the housing market, and as you said, it's Victorians, New South Wales, relocating up. So Coast is certainly pumping at the moment. Rentals are in high demand, very low vacancies. It's actually an interesting time.
So I think also, I don't want to spend too much time on it because obviously we're, got to get on, but it's quite interesting that with both the Goldie and, or maybe to some extent, the Sunshine Coast, you've got wide open spaces as opposed to living in a city which is very prone and will continue to be prone to lockdowns. And I think that's one of the areas that's really going to be a big shake for people.
Yep. So safe harbour provisions, I mentioned just before, but introduced in September 2017 to the Corps Act, and effectively provides directors with protection from insolvent trading liability as long as they are pursuing a turnaround plan. So if a director or the board of directors suspect that their company is in the process of becoming or is insolvent, they have the opportunity to put in place what is a safe harbour plan. And it is just, it's effectively a number of, or a course of actions that will likely lead to a better outcome for the company than immediately appointing an administrator or liquidator. We've just put one in actually yesterday for a client. They're charging us, they're paying us an upfront fee for the actual plan. There's a strategy that we develop behind that, and then we should get charged. We receive a monthly fee for effectively managing and administrating that plan, or our back office does. Just the next slide, Grant.
Coming. Just, I was really attracted by that Byron Bay lighthouse.
Yes. So unfair preferences in relation back period. What's that? So unfair preference payments relate to during effectively the relation back period, or when a period in which a company is believed to be insolvent or trading insolvently, and it provides that certain payments during that period can be clawed back if they are paid in a preferred way. And that falls under section 588FE and 588FF of the Corps Act. So for a payment to be considered to be unfair, it must have been made to a creditor and a creditor of that company, and they must be unsecured. So that's pretty important. We're going to have a webinar next week on PPSR and securing creditors, and we see it all the time in relation to, we get clients referred to us. There's director loans, which are liabilities sitting on the balance sheet, so money owed to the directors, and there hasn't been a loan and security agreement put in place, and more importantly, that loan and security agreement hasn't been registered with the PPSR, so they're not a secured creditor. If that is in place, then they actually rank ahead of the ATO, assuming they've lodged on time, and they rank ahead of unsecured creditors. So if we have to do a restructure or wind up the company, the director would be paid as a secured creditor, and there would be no preference payment in relation to that. So often we can get cash back out to directors as long as they've been adequately secured. Now, what is the relation back period? What is the time period? For non-related creditors, so non-related to the company, that's 6 months from the relation back date. For related creditors, it's 4 years. So you've got to be cautious in relation to that. And if there's an attempted delay of fraud creditors, it's 10 years before the relation back date.
So what's a related creditor?
Related creditors, so mum, dad, related companies, related trusts.
Yeah.
Related entities.
Gotcha. Yeah. So I wonder if it'd be interesting with the SMSF where that fits in there. But I think the contribution side is a little bit different. We're going to have a look at. So
yeah,
so the 4 years are back from obviously the voidable transactions that we've got. So that's quite a significant one there anyway. Okay, so this is what it's all about, building that moat around the client. Now, the client might already be in the midst of battle. It doesn't seem as though, as Mick said before, there's not that many battles about around insolvencies or trustees in bankruptcy, but it will come. As I said, the tsunami, that tidal wave has flown in, and it was going to come back, and it's going to expose those people who effectively have got no clothes on. And look, Phil Scandizo, who just made a really good comment, well done, Phil, is that for many of our businesses, it's going to go right back and rebuild as a startup. And no doubt, I mean, what advice would you give, Mick, for a lot of these businesses who have got clients on JobKeeper? Are you seeing them now starting to cull and really look at shape-shifting their workforce and making a completely different sort of business, a lot leaner?
Oh, they are. I mean, I've had a large number of, or a number of people contacted me in relation to starting up discussions on offshoring and outsourcing. Obviously, I've spent 10 years over in the Philippines doing that. And I think that's driven a lot to do with the fact that we've been working at home. Businesses have been working at home. They realise they don't need necessarily the leasehold space in the capital city. They can reduce that, and they don't actually need to have staff in the office every day. They can actually look at different ways. But certainly, what Phil was saying there, it is an opportunity for a startup again, and to look at ways that you can restructure. And when we do a number of restructures as part of strategies, and obviously you've got to be cautious and wary of the phoenixing provisions and stuff, but you can actually, there are a number of businesses that still are great businesses, but they may have got themselves into trouble through taking on too much debt, using the ATO, I guess, as a treasury facility. And as long as you follow appropriate processes, there are ways to restructure and re-engineer those businesses and become successful businesses. And part of that can often be obviously looking at reducing staff and other operational expenses as well.
And look, that's not, it's again, I mean, Mick and I were talking about our own taxes before, and we tend to help everyone else before we actually help ourselves. But that also goes with accounting firms. I mean, when you start to have a look at the automations that we do, that high end, being able to do the estate planning, the succession planning, this insolvency stuff, this is where there's really good money. We're right at the pointy edge of the curve for that. So, and plus, it all can be done by the advisor, whereas the accountant or the planner themselves, they don't need. In fact, it's quite detrimental to pass it down to a junior. So it's not a bad time to reshape what a modern accounting firm is post-COVID, which is good. So let's have a look at a case study. What I've got one here, I've just got a one, I want to rip into SMSFs and show you some really fancy things around that. But I've got John Smith, who's a doctor, age 60, second wife, Sally, who's age 48. He runs a successful medical practice through a discretionary trust. So that's not a bad idea. We're with a corporate trustee where John holds all the shares. Now, he's got a Smith family SMSF that's got 1.2 million in his accumulation balance for John. So he hasn't hit his total super balance of 1.6 yet. So he's just got 1.2 million accumulation and 250 for Sally. He's also got his son, Max, who's from the first marriage, who's a member of the fund, who's got 200 grand. Max is 38, successful pharmacist, happily married with 2 young children, Ben and William. The trustee of the SMSF are individuals. So we've got Max, we've got Sally, and also John. So you're starting to get a bit of a drift. Everything looks fine. Everything looks okay. But now we start to hit a few snags. John owns a family home outright, which is worth 2 million and has no debt. John also owns a commercial property, which is now positively geared, market value of $1 million and a loan of $500,000. So again, it's not a bad investment, but he's put everything in his own name, which is pretty typical because of the tax rules in Australia. Obviously, we want that family home in our own name, so we get the CGT exemption. As I said, the last thing it should be, so this was the original family home, but you don't want to have that in Sally's name. Sounds good for asset protection, but not really, because if Sally ups and runs, then John's really stuck out on a limb. And more importantly, when we have a look at going down that track, their commercial property is also exposed. Now, and this doesn't make, this is pretty typical for a lot of us in the professional services. A patient has claimed medical malpractice against John. And at this stage, his PI insurer is yet to be informed. So you want to make sure that when you've got clients like this, that they're actually knocking on your door and saying, look, we need your help. Because the way I see him exposed is effectively the shares of the corporate trustee, he's exposed there. The trust, the discretionary trust is exposed because that's where the medical practice. So he's going to get sued, and the trustee of the discretionary trust and the discretionary trust are all going to effectively be sued there. Now, just to put a bit of a tinge on top, Sally and John are having marital problems. So we've got everything in this case study. I wanted to just take you through and have a look at SMSFs. And for those of you who aren't worded up or really understand what how the Bankruptcy Act applies to SMSFs, I wanted to do a bit of a deep dive there for you, take you through the legislation. I'm going to take you through a little case that we've looked at, happened in 2016, and then we can move on. Then I'll recalibrate that case study and give you my solutions there. Again, this recording will be out this afternoon, along with a PDF of the slides and a couple of other little things as well. Okay, so let me just bounce out of here and then go and start to have a look at the legislation that's relevant. So the first thing that what I want to do is I've given it in exactly the list, and this is the way that I sort of move into things. So what I want to do is just have a look at the SIS Act. I think I've got one there. I'm not sure if I open that up. Now let me just go and get my SIS Act. So just on the slides here. So I'm going to have a look at, there we go, the SIS Act. Okay, so I'm just going up here. So under the SIS Act, what I need to do is have a look at the definition of superannuation interest. And generally you'll find, for example, if you have a look at the Commonwealth or Corporations Act, particularly as it applies to financial services, that the definition of a financial product is deemed, doesn't mean it happens, is under the ordinary sense of the terms, is deemed to be include a superannuation interest. So this superannuation interest that I'm looking at now or taking us to in Section 10(1) of the SIS Act is important not only for financial services and understanding whether we need to be licensed or not, but also in terms of bankruptcy. So it's such a small, short thing, but it's absolutely crucial. So let me get down to superannuation interest. We've got superannuation entity, and here we have it here. So one line can mean an absolute huge impact. So a superannuation interest, which is a financial product, means a beneficial interest in a superannuation entity. So for example, a beneficial interest would be someone who is contributing into a fund. That is classified as a beneficial interest in a superannuation entity. For example, if we do an investment strategy, that is not a beneficial interest in a superannuation entity. That is something that the trustee of the fund does. So it's definitely not a beneficial interest. So it means that it is not a financial product. If we take a lump sum out, or we tell our client to take a lump sum out, then obviously we're dealing with a beneficial interest. The same with a pension. Now on death, if we're doing a BDBN, or my preference, as you've heard before, is an SMSF will, we're not dealing with a beneficial interest. All we're doing is working out a contingency plan as to what might happen in the event of the death of a member. But for example, and listen here, for example, if we've got a BDBN and the monies are going from John to Max, so we're bypassing Sally, they're going from John to Max. Does everyone understand that one? Once that lump sum comes out to Max, then we're dealing with a beneficial interest, but we're dealing with Max's beneficial interest inside that fund. Now, I'm not going to have time to go ahead and have a look at it, but that protection that we've gone from John to Max, effectively cutting out Sally in that instance, and you know that we can do a SMSF death benefits trust or testamentary trust for Max, if we can show that he, because obviously he's a dependent, we can set one up for him and also Ben and William, which we looked at yesterday. In that instance, Sally hasn't any right of recourse, as opposed to if those monies were sent over to a testamentary trust in the estate where the executor sets it up, not like an SMSF testamentary trust or death benefits trust, which is set up by the SMSF. As soon as it goes over, effectively subject to family provisions claim, and Sally would get a lot of it. So we're looking at section 10.1. Now, what I need to do is just take you, we're going to drift over to the Bankruptcy Act here. So I've got the Bankruptcy Act up here. And what I'm going to do is have a look at, Michael's already taken you through the basics, but the property that is divisible amongst creditors, which is important. I might just open up that a little bit so you can see it a little bit better. How's that? So my eyes are probably pretty shot to pieces, as many of yours are. So we've got a whole lot of property that's divisible to creditors. Obviously, all property belonged to or was vested in the bankrupt at the commencement, and plus anything that then comes to them afterwards. So there's a lot there. I'm not going to take you through that. I think most of us understand bankruptcy well enough. Now, the big thing for us is subsection 2. So subsection 2, so section 116 talks about property divisible among creditors, which is subsection 1. Subsection 2 talks about exceptions to the rule. So it doesn't extend to any of the following property. The first one, obviously, household property, etc., personal sentimental assets as well. A couple of other things here that I really like is subject to subsections 128B, C, and 139ZU, we've got some specific exemptions. Policies of life insurance in respect of the life or the bankrupt or the spouse or de facto partner of the bankrupt. In that instance, a policy of life insurance is excluded from being property that's divisible by creditors. And also the proceeds of such policies received on or after the date of the bankruptcy. So, for example, if a spouse is bankrupt and receives the life insurance proceeds on the death of their spouse, effectively that is not property that's divisible by a creditor. But I'm just going to wipe those two out for us. And then what we're going to look at now is superannuation. So the interest of the bankrupt in a regulated superannuation fund. So importantly in that one, where we have money inside a superannuation fund, if I go back and we have a look at the slides here, and we have a look at, so let me go back to the case study. We've got there, let me just open that up a little bit. We've got John, who has $1.2 million in accumulation account. That money under the Bankruptcy Act, under section 116, 2D, I think it's 4, let me just go through, 216, D3, that interest is excluded from the trustee in bankruptcy, which is why I say that an SMSF and a superannuation fund is one of the best and most practical asset protection tools whatsoever. So first off, the interest is in. Now, this is even more important to me, and this is probably the most exciting. A payment, and let's have a look, a payment to the bankrupt from such a fund received on or after the date of bankruptcy, if the payment is not a pension within the meaning of the Superannuation Industry Supervision Act. So again, so while it's in this phase here, when it's in the accumulation phase, effectively it is protected from bankruptcy. But when we have a look at the second one, a payment to the bankrupt from such a fund received on or after the date of bankruptcy, if the payment is not a pension. So if I go back and have a look at the case study here, so we can put some flesh on the bones, we've got John Smith there, who's age 60. For those of you who followed me before, the definition of retirement under 1.067 of the SIS regulations is that if John gives up one form of gainful employment, for example, being a locum at a local hospital, then effectively he's deemed to be retired. So all his $1.2 million that we have there, effectively, that is going to be unrestricted, non-preserved or unpreserved monies. So John can take that money out. He can either set up a pension or take that money out as a lump sum. Now, this is where it becomes really important when we have a look at that, is that if we take it out as a lump sum, any payment from such a fund is not going to be treated for the creditors, so to speak. So it's not divisible amongst creditors. If he starts taking an income stream, well, that's where we've got problems, because each of those income payments are going to be part of his income, which is then able to be attacked by his trustee in bankruptcy. Does everyone follow that one? So we've got two different plays there. In fact, we've got three plays. If you're in the accumulation, you're protected. But if we look at John here, we know that he can actually take money out of his fund and live on it, and effectively it's not as a pension, which is quite surprising from that one. And I just wanted to show you, I've got another little thing here. If I can find where it is, it must be up here. I just wanted to show you this. I thought it was quite interesting. Just while we're here, as you can see here, Estate Planning 101 workshop, November the 18th, and that starts, I forget when it starts, but we'll send you details on that. So let's have a look at here, not super central. We've got limited recourse borrowing arrangements, federal court, new case. Thank you very much, Dan Butler. Let me go back. Sorry, don't want to do that. Sorry, that was my disco thing. So sorry about that. NAB. Oh, here we go. Okay, so this is the Australian government, the Australian Financial Security Authority. So I just want to put this up because this is really, really important. So it actually goes to exactly what we're doing. So what happens to my money in the event of bankruptcy? So this is absolutely crucial. Can I keep money or bank account, blah, blah, blah. So this is going to be the first port of call. Now, when we come around to superannuation, is superannuation affected? We've got a whole lot of stuff there. It's merely most of the stuff that I talk about, but I wanted to show you this case study of Karen. Karen is a 63-year-old retired teacher from Swan, Western Australia. Karen found it hard to manage her debts after retiring from a full-time job. She became bankrupt in March 2018, so she's bankrupt. Karen had $659,000 in her regulated super fund. Karen's car was recently written off in an accident. She did not have insurance to cover the damage. In October 2019, while still bankrupt, she applied to release a $50,000 lump sum from her superannuation fund. The amount was approved and deposited into a bank account in November 2019. Again, she's met a condition of release, so there's nothing there. Karen used some of this money to buy a new car. She used the rest of the money to send to her grandchildren, to visit family in England. Good old Karen. AFSA received a phone call from a creditor of Karen's bankrupt estate, as you can imagine. The creditor was angry that Karen had bought a new car and paid for an overseas holiday. The creditor demanded the trustee take the car as an asset in the bankrupt estate. ASPA contacted Karen and discussed the new car purchase and holiday payment with her. Karen told ASPA that she paid for them, and this is important. Karen told ASPA she paid for them with the money from her super and fund. ASPA asked her to provide evidence. Karen was able to provide full evidence of the payment transfers from the regulated super fund to her bank account. Her bank account showed full payment to the car dealer and to the travel agent. It was clear these payments had been made using the superannuation money. Under the Bankruptcy Act, Karen's lump sum superannuation withdrawal after bankruptcy is protected from her creditors. Assets purchased with this money are also considered to be protected. This means that those assets remain safe and it cannot be taken for the benefit of the creditors. And this is why I'm telling you, superannuation, particularly compared to obviously companies and individuals, but even to a trust, is far better. Karen, and the same thing is, if I take us back to this situation here, John could be a bankrupt and still take out $500,000 from the super fund as a lump sum, provided we meet the condition of release, use that to pay off, whatever, pay off part of that loan that he might have in that commercial property or do whatever, and effectively it is going to be protected from bankruptcy, not the family home, not the commercial property. Likewise, any distributions from the discretionary trust to John, which you would want because Sally and John are having marital problems, they will be caught up by the trustee in bankruptcy. So the Smith family SMSF is the golden gift in terms of asset protection, and one that is not known in many certain circumstances. Kush, can you commute a pension after bankruptcy? Absolutely. And if you go in, you'll find within the legislation that when you do that commutation, is to be treated as a lump sum rather than a pension. Ideally, just to make extra protection, because there hasn't been a case on this. Obviously, the trustee in bankruptcy is going to have a go at it. You roll the pension back to the accumulation stage and then use that as your fully protected superannuation asset protection bank account and just live off that, which means when we have a look at that, we want to make sure we've got as much superannuation as possible. David Shipcott, are the SMSF super benefits of someone who's filed for bankruptcy exposed if the SMSF has had its regulation details removed due to non-lodgement as at the date of bankruptcy? The problem there, well done, David, is that it has to. Let me go back. In fact, I'm not going to talk about it. I'm going to go back and let's have a look at the laws, which is a great question, David. So what is exempt? The interest of the bankrupt in a regulated superannuation fund. So that's important. Interestingly, David, I'm just having a look at this one, is that 4 doesn't say it has to come from a regulated superannuation fund. It doesn't say it has to come from a regulated. Mind you, when we do that, we've got to be very careful that it's not a regulated superannuation fund. So it's been struck off. Effectively, it is not a superannuation fund. It's treated as a trust. So we've got to be very careful about that one. But look, what I would be doing is rolling the monies over to a retail fund, because while it's in that system, effectively, it's going to be protected. Again, these are the sort of things that we need to knock around. I wanted to also show you this case, which is interesting because, for example, I talked about the monies going from, remember I talked about the money's going from John dies and it goes down to Max. It's now his superannuation interest. How do we know that? Well, effectively, we know that from section 10.1. Importantly, from that perspective, what happens if Max is bankrupt? I mean, that's one of the reasons we set up testamentary trusts to protect from bankruptcy. But what about Max getting this lump sum or a pension? Would that mean, well, obviously he can't get a pension because he's over age 25. Taking that lump sum, would he be protected? This case here, I'm just going to go through a couple of little issues here. So this is the trustees of the bankrupt. So this is Debbie and Debbie, the respondent. We'll just go through here. Debbie is a bankrupt, so that's easy. She's a widow. Her late husband died on the 19th of May, 2013. On the 23rd of December 2013, a payment of $45,000 was made from a retail super fund to her. And on the 26th of March 2014, a payment of $67,000 was made to her as well. In addition, she received a payment of $3,000 by way of life insurance and related anti-detriment. So she ended up with probably around about just over $430,000 coming from superannuation. And obviously, the trustee in bankruptcy was rubbing their hands in glee, trying to get a hold on it. We've gone through all the legislation. We don't need to do that because the court just simply has gone through and paraphrased what we've all had a look at. Certainly a great case to focus in on, and I'll make sure this is in the materials as well. You can see it's only about 8 or 9 pages long. It's not that apart. For her part, so in this case, Miss Morris, as trustee in bankruptcy, contended 2 payments did not fall within any of the items listed in section 1.2 and are called by section 1.1.1 and are divisible. And the reason they're saying that is essentially that she didn't have that superannuation interest. For her part, Mrs. Morris contends that as to each of the Safe Super and Plum Super payments, they each fall within either of each of the items in 2D3A or 2D4. 2D4, remember, is the payment of a lump sum, alternatively property. Further, alternatively, respective Plum Super is put on behalf that the payment in any event falls within 1162A. So when we're having a look at it, 1162D, we've got there, it's the regulated super or a payment to the bankrupt from such a fund received on or after the date of bankruptcy, as long as it is not a pension payment. So let's go down and see what the court held. I'll just go right down to the bottom, and when we have a look here. And they talk about the intent of the legislation. In respect of both the Safe Super Fund, the Plum Super Fund, prior to the exercise of the discretion in her favour, whereas I found in her favour and that of the late Mr. Foreman, her dependent children, Miss Morris had no interest in either of those funds. Sure, the case may be, she and her children were nothing more than the objects of discretionary power, which is what I've said. If you did a BDBN, there's nothing there until they die. They had a right to the due administration of each of these funds in accordance with respective governing deeds. Now, there wasn't no BDBN, so it was discretionary, and the trustee decided to pay it out to it. That interest was not proprietary, but upon the favourable exercise of the discretion, a proprietary interest was created. And that interest was quite literally an interest in a regulated super fund, the superannuation interest. But there is no dispute between the parties that each of AusSuper and Plum Super is a regulated super fund within the meaning of the SIS Act. So they're using that 2D3A. That being so, Ms. Morris had an interest which fell within the terms of exempting item in 2D3A. Remember, we had a look at that. Further, when we go through and have a look down here, were it necessary to decide 2D3A and 4, which is the payment of the lump sum to her, applicable is not, I would additionally hold in respect of Plum Super that it was exempt under 216 2A of the Bankruptcy Act. So that even though she was a bankrupt, and this is the fantastic thing about this asset protection, not only is it within the fund, but lump sums paid out of the fund, lump sums paid to bankrupts out of the fund effectively are going to be protected from the trustee in bankruptcy. And that to me is absolutely amazing. Of course, when we're dealing with self-managed super funds, we just have to be really careful because we can't be a trustee of a self-managed super fund if we are bankrupt. We've got 6 months to reorganise our affairs, so we might find our way into a retail superannuation fund. Of course, once we become an undischarged bankrupt, again, we can potentially maybe go back and have a look at things there. Okay, so we've had a look at that. I'll send you through the slides. I'll send you through trustee of the property of Morris and Morris, the bankrupt, which is quite interesting. Now, with the moat structure, you've seen me do this before. That red line's horrible because not only can you imagine that super money going over into our estates and potentially if the person was a bankrupt, then we're actually opening it up, that whole estate to bankruptcy and sucking in the superannuation. So superannuation should always be left alone, should never, in my view, go over into the estate, except in very limited circumstances. My preference is the Family Protection Trust for the protector with a leading member trustee company. With a discretionary trust, turn discretionary trust into leading members, again with a leading member trustee company. So there's succession, as Mick said, there's a lack of succession. Ideally, because we've got problems in this area, potentially there's bankruptcy or there's certainly claims coming against John. He's also got marital problems. We want to have John as the first leading member, or now make it Max. Let Max have control. The same thing. LMS, so a leading member SMSF trustee company and a leading member SMSF. So we want to sort out the SMSF first, get a leading member SMSF corporate trustee and also upgrade to a leading member SMSF. So what I would do there, I would have the corporate trustee, I would have all the shares owned by, at this stage, it could be owned by John, which is fine as the case. But if there's an action against him in bankruptcy, he can resign and the next leading member, who is Max, comes in, his shares are cancelled and they're now reissued into Max's name. So Max now controls that self-managed super fund as the leading member, has the power to veto. So again, we've got a really good, strong case there. Max up the contribution. So we've got 1.2. We want to put in as much as we can. Once we hit 1.6, so my thinking is actually transferring that property into a self-managed super fund, get it out of his name, put it into a self-managed superannuation fund. At least put $400,000 contribution in there if that's possible. So we do an in-specie transfer. It can come with a related party loan. However, that LRBA will also be included as part of the total superannuation balance, but it's not treated as a contribution. So once the LRBA goes in, to the extent it's sitting in there for John, it's going to lock him out from making future NCCs and also future catch-up concessional. But he can continue to make concessional contributions up to the cap. So I'd be looking at maximising that, because again, whatever he puts in, he can pull out and it's protected from his trustee in bankruptcy. When we have a look at the contributions, which is really important, I'm going to bounce out here. And at this point in time, let's just have a look at the Bankruptcy Act and go down and have a look at, importantly, what happens with contributions. So there's just a couple of things. It's not a big one here. Section 128A, this subdivision enables the recovery of superannuation contributions made to defeat the bankrupt's creditors. So the idea of clawback doesn't apply in terms of superannuation. So when we have a look at transfers that are void, when we have a look at this, a transfer of property by a person who later becomes a bankrupt to another person is void against a trustee in the transfer's bankruptcy if the transfer is made by way of a contribution to an eligible superannuation plan. So that's okay. And remember, with the LRBA, your trustee in bankruptcy is going to be taking that on foot, obviously. The property would probably have become part of the transfer's estate, would probably have been available to the creditors if the property had not been transferred. So that's okay. So we're looking at in specie property or cash. And now this is the one. The transfer's main purpose in making the transfer was to prevent the transferred property from becoming divisible among the transferor's creditors. So, or hinder or delay the process of making property. So this is completely different to the ordinary circumstances. So at this present point in time, I'd be loading John up because we're not trying to defeat his creditors. He has no creditors at this point in time. We're trying to maximise his super. And why is that? Because he's 60, he's moving towards retirement. And have a look through there, obviously showing the transfer's main purpose of making a transfer. The transfer's main purpose of making a transfer is taken to be the purpose described in paragraph 1C. If it can reasonably be inferred from all the circumstances at the time of the transfer was about to become insolvent. That's clearly not the case. In fact, what you want to be doing is when we go back here and have a look here, get the discretionary trust sorted into a leading member discretionary trust with a leading member corporate trustee. Absolutely. Get the protector. So for the existing family home, and also that part that we haven't put into superannuation around the commercial property would also be gifted over to a family protection trust, which is absolutely crucial, and a registered mortgage laying back on both of those. Part of that is part of the protector, if you've done one before, is you need a solvency certificate. So again, there's the superannuation contributions are a lot less onerous than effectively we have in terms of already property divisible by creditors. So certainly I'd set up the Protector of Family Protection Trust. As I said, max out contributions, use a related party LRBA. With that related party LRBA, which is important, if they've got that for the equity or they're going to reloan, again, just go through the process of getting external bank, etc., and having a look at that. But that's where you can come to us at any point in time and ask us your lot of questions. Make sure if he's got Sally's EPOA, don't have her as a director of that leading member corporate trustee. John's got the EPOA, so he's acting on her behalf. She decides to move out. Now, the only problem we do have, it's great for asset protection, but under matrimonial property, this is where we're going to get stuck with our superannuation. So he's going to have to keep Sally on side there, and we put Max in as a successor leading member. We've talked about the protector. Most of you know that. So that's the strategy I use. And again, SMSFs are brilliant for asset protection. Anyway, Mick, do you want to take us around for the last 10 minutes and look at some of these case studies that we put in place?
Yeah, thanks, Grant. I'll jump through them fairly quickly, obviously running out a bit of time, but we will be, as Grant said, start doing, I guess, a mini series on insolvency, pre-insolvency business turnaround, and we'll deep dive into these and look at balance sheets and really get into the numbers. But effectively, both case studies are dealing with probably one of the biggest concern when we see pre-insolvency clients is protecting their residential property, their principal place of residency. And as Grant mentioned at the start, wealth means nothing if it can evaporate in a minute at the whim of a regulator. So in this particular case, we've got John and Alex, husband and wife, the joint tenants on their PPOR. John's company's been failing. He's sole director, which is fantastic that Alex is not on there. We often see that as well. So John's facing bankruptcy. Property's worth $1 million. Originally, they took out a loan of 200,000, which would, on the face of it, give them 800,000 equity. But subsequent to that, John needed working cap in the business, and he took out a loan himself, secured against property, of 400,000. So net equity of 400,000. John's share of 200,000 was at risk when he come to see us. Alex, in this particular case, did not have any funds available to acquire John's share. Often we put in deeds of equity and we transfer the equity, and in that case, Alex would actually pay John for buying John's share of his equity, but in this case there wasn't. So options available. Jump on the next slide.
Going. Yeah.
Yes, there is. It's called the DOE, the Doctrine of Exoneration. So if there's borrowings that would benefit one party, that one party had taken them out, John, for the benefit of the company of which he was the sole director and shareholder, and not the other, being his wife, shall be allocated, as long as we use appropriate documentation and appropriate process, to the benefiting party. And so the result of this was that John's equity came back to nil. So 500,000 less the 100,000 from the original loan, and the full 400,000 results in equity of nil, and meant that whilst we had to put we had to use an insolvent specialist to and John got placed into bankruptcy, they kept their principal place of residency.
Can you just go through and explain that again? So
yeah, so
property worth $1 million, original loan 200, subsequent loan by to John
400,000 that he took out in his own name, but it was secured against the resi property.
Yep.
Generally, people would say, okay, you've got 1 million minus the 2 and the 400, so 400,000 equity, 200 each, because they're joint tenants on the PPLR, so 50-50. However, due to the doctrine of exoneration, obviously these are cases where someone hasn't been proactive, doesn't have the protector or moat or similar products in place. Asset protection hasn't been there. The business is failing, so it is insolvent. So you can't retrospectively start putting structures in place. We've been able to use appropriate documentation and utilize the doctrine of exoneration to allocate that equity that related purely to the benefit of John and not of the spouse, and bring John's equity back to nil. So the bank under bankruptcy, they kept their principal place of residency.
Awesome.
There is under the case study too, effectively similar situation. There was a bank secured business loan against principal place of residency. There was ATO debt, I've noted, lodged on time. I cannot say this enough, and I'm sure all of our listeners are aware of this, but it is paramount that your clients lodge their activity statements on time. They will not be personally liable if it's lodged on time. There were some personal guarantees to creditors. They were struggling to pay. If Alex had also been a director, which sometimes you see, then obviously they both would have been under attack. There were some employee entitlements and superannuation. The principal place of equity split was John had 50K and Alex had 150K. Alex in this position had access to cash resources. Are there options available? In this situation, yes, there is. We looked at an equity transfer. Alex was able to pay John. Generally, in that case, we ensure that both individuals have their own bank accounts. There's a process to follow in relation to paying them. We have to be cautious that in equity can also be built up over time from, for example, myself and my wife, I'm the main breadwinner. And whilst we might own a property 50-50 and the loan might be the same, because I'm contributing to the mortgage, I'm actually building up my equity over time in that actual property. So we have to review that often and ensure that the appropriate equity is purchased at the time. So it's not just necessarily about title; it can also be about contribution.
And how do they test Phoenixes?
Phoenixes, well, I mean, it's heavily looked at area now, especially in the, I guess in The space that Eventum Optimum works in pre-insolvency and stuff. There's a number of things they look at in terms of the use of friendly valuers, friendly insolvent practitioners. So it's important that you have, we have a large panel of insolvency practitioners we use. We have a large panel of valuers. We often, Eventum Optimum, all our referral base comes in from accountants, financial planners. We have some lawyers as well that we work with. And we ensure that we spread that work back out and we have no involvement in relation to the valuation. We ensure that if an accountant such as Tim refers us a job, then we wouldn't get Tim obviously to do the valuation. We ensure that's completely independent external party. And we're able to, you can still transfer businesses across to a new entity and restructure them as long as you follow the appropriate processes and put the appropriate, documentation is key. We say it all the time at Like Your Docs, but it's you got to put the appropriate and right documentation, and you got to follow the right process.
Absolutely. If you don't do that, you're virtually stuck. And I think that's crucial.
So I've just put up there that, as I said, like we have Eventum Optimum. My business partner is ex-head of compliance at ASIC, and he was ex-senior advisor at De Jong Reed. He has a large amount of experience in this space. We have a back office team in Newcastle and Melbourne. So we have offices down there that effectively we work with the clients and put the strategy in place, and then they assist us with implementing it. We do a lot of the dirty work, I guess, with Creditor and Creditor negotiations. We've recently negotiated with Westpac Bank. One of our clients had a facility for 1.3 million, and we got it down to a repayment of $50,000. That doesn't happen all the time, but we work with a number of, we're often the creditors we're working with are like cash flow lenders. You see a lot of that in this space when there's when businesses are struggling and having and then we work with restructuring them, liquidator appointments. We have a panel, as I said before. We have a number of funding and finance solutions. A lot of my experience has been obviously listed an ASX company of I have access to a number of different debt and equity solutions that we can assist clients with. But more importantly, what we do and why sort of Rod brought me on board is we often work with the accountants and advisors clients and help them in relation to putting the strategy and stuff in place. But also we offer ongoing management consulting. I sat as a CFO on ASX listed and unlisted companies, and we like to, not just assist them in restructure and help them now, but we meet with clients on a quarterly basis afterwards and ensure that they're continuing on the right path. And we work with their accountants, obviously, in that process. And so it's not a matter of just helping them and forgetting about them. It's about maintaining that relationship.
Absolutely. And I think that's absolutely crucial. I know you've certainly helped quite a few people from our Like Your Docs advisor base.
So that's effectively the process we go through. So we put a strategy plan in place, review the options, work very closely with the accountant, and where we can refer work back, we refer is company setups or trust setups or using the protector or the moat. We get the accountant to do that. We're often quasi debt collector for the accountants or the advisors. When the client first comes to us, we always make sure our first thing is before we engage them, we say, okay, let's have a look at your creditor list, and the accountant's on there who's advised us. We say, well, look, you need to make payment of that or immediately, or work out an immediate payment plan, or we're not going to engage you. So we look after the referrer, and we move forward then with the plan.
Perfect.
There's some contact details I can send out later.
Okay, so just wrapping everything up, a few things we've got, obviously, as I said, Estate Planning 101, which would be great. So I'll be doing a blog this Friday. Watch out for that, which is going to be on accountants and financial planners being able to provide, obviously, estate planning advice and also be involved in the process of the documentation, drafting up wills, testamentary trusts. As I said before, all of that stuff is anathema from asset protection because it sits on the other side. Once it goes into the estate, first off, you've got to wait forever to get probate. But if we can do everything through the self-managed super fund, you can even pay out to bankruptcies we've seen in the Morris case. So self-managed super funds in terms of insolvency it's a great opportunity to get your clients in and get them sorted out at this current point in time. Contributions, max out the contributions while you can before there's that solvency issue. Remember, one of the big areas there is that if the person's insolvent, obviously that looks as though they're going to defeat the creditors. Completely different style to all the other issues that are in the Bankruptcy Act. But look, it's Grant Abbott and Michael Jeffriess. Thank you very much, Mick, for turning up today. And we'll let you know. As I said, 18th of November is our estate planning. And if you're available or able to come up to the Gold Coast, many of you aren't, make sure you get involved, and we'll be up there for a breakfast session on the 27th of November, which I'm pretty excited to get out and actually start talking and using my feet. Of course, we've probably all got a few COVID kilos in there anyway to worry about. Anyway, it's Grant Abbott. Mick signing off.
Thanks. Bye.